Hopefully a quick review of Chapter 10, Illegal Contracts. It's a little bit of an easier chapter to digest, other than a couple little nuanced areas that I think sometimes throw people off a bit. First, I want you to realize that if a contract is illegal, it's not always about criminality. When you hear illegal contract, you must mean, it's about a illicit drug transaction or about hiring a hit person to kill another competitor. Yeah, those are clearly illegal contracts, and they're void. They're not enforceable. You can't go to court and say the other party didn't perform. I want them to either perform or return my money, things like that. You can't sue over the enforceability of an illegal contract. But a lot of illegal contracts have nothing to do with what we think of as moral wrongs or mala in se crimes. Sometimes they're things we wouldn't even realize they're illegal, except for administrative rules and regulations that have barred certain kinds of behaviors. One I think about is at one time it was illegal, I think, in Massachusetts to have ferrets as a domesticated pet. What if you didn't know that and you just saw somebody who had ferrets and said, hey, we have these ferrets for sale, and I go and buy 2 ferrets for my kids, and I find out, or we find out somewhere in the midst of the contract that that is actually illegal, it's not allowed. That would be an illegal contract. No one was trying to do anything illicit or inappropriate. We just didn't know. And that's not a defense to the law, but what does it do to our contract? If it's executory, it makes it unenforceable. This is an important concept. What do we do when we find that we're involved in something that we didn't realize was an illegal contract? We leave the parties where we find them, meaning that, say I bought the 2 ferrets and I gave the money to the seller of the ferrets. The law would not get involved after the fact and say, hey, that was an illegal contract. Let's undo it. Let's rescind the parties standing to the antecedent time. Let's give the ferrets back. Jim, you get your money back. They would leave us where they find it. I'd now be stuck with 2 illegal ferrets. Maybe they'd be confiscated, or I'd have to return them to some wildlife agency or something like that. So we don't interfere and undo things that are completed. If it's executed, we leave the parties where we find them. If it's executory, meaning I haven't paid the money yet and the ferret salesperson hasn't given them to me yet, the contract is just simply null and void. It's unenforceable. Neither party should perform. What if I gave the money but they haven't given me the ferrets? Are we going to leave them there? No. One party can't benefit by the other party's inability to comply with an illegal contract. That's called unjust enrichment. We did that in a later chapter. They're getting money, I'm getting nothing. I should be able to get my money back. So it's a common sense principle. Now, what's not always so common sense is what is illegal. Like I alluded to, the obvious ones like drug transactions, hiring someone to rough somebody up or kill them. Those are clearly illegal. But your book does a nice thing about outlining some of the gambling contracts. Some are legal. Massachusetts now has certain large lottery avenues to gamble your money legally. And now we also have casinos. Those are sanctioned by the state. When this book was written, and the book was written by a former senator from Missouri, where I don't know if there's a lot of legal gambling there, but generally speaking, illegal gambling contracts are in fact unenforceable, and you can't sue to enforce those. Sunday contracts, not nearly as a big a deal as it was one time, certainly when I was a kid. What are Sunday contracts? Many states used to have laws that basically said you're barred from doing transactional business on a Sunday. These were called blue laws, and clearly there's a religious context to those, and they have been challenged and pretty much undone in, I'd say, modern times. When I was a kid, there was a shopping plaza down the road from my house. If you went up there on a Sunday, you could see tumbleweed going through the parking lot. There were one set of cars, and that was at the bakery. That was the one shop that met an exclusion for the Sunday laws. I guess it's still an important concept. I guess for liquor stores, they can only open at a certain time. When I was a kid, they couldn't open at all. It could be a retail establishment like a bar or restaurant, and you could serve alcohol, but you couldn't sell it to be transported to another location when I was a kid. Sunday laws are no longer very important. Just nice to review for historical context. Usurious contracts. There's a couple of test questions on. This is still an important area where it surprises a lot of people that there's illegality here when you charge interest that's above the law maximum. So many people, hey, you want to borrow $10,000 from me? If I'm in the business of loaning money, I have to be a licensed lender. But if I'm not, if I'm just a casual lender, I can lend money for interest. There's nothing that prevents me from it. It might be a nice investment. I know someone who's got a really good job, and for whatever reason, they need some money now, and say, I've got some cash sitting around. It might be a nice investment for me to seek the money back in 6 months at 10% interest. That would probably be a totally legally inappropriate contract and a good way for me to make money. Obviously, if they don't pay me, I can sue them. It's a debt that's just. What's interesting about that is a lot of people don't realize that. Say, hey, can I borrow $1,000 and I'll pay you back $2,000 in 2 weeks. Boy, that sounds like a great investment, especially if it's a reliable person that I trust. But if you're doubling your money in 2 weeks, what's the annual percentage rate on something like that? Well, I'm not a mathematician, but it's clearly well over 100% because you're making 100% of your money in literally 2 weeks, never mind per annum. I know it's tens of thousands of percentage of interest points. If it's very severe, it might even be called what we call loan sharking. A lot of people don't understand what the difference between loaning money and loan sharking is. Loan sharking is basically charging an interest rate at an usurious. A usurious is too high beyond which the law allows. And the law gets into this realm is because they don't want people being taken advantage of. We all know it. Sometimes we've been at points in life, boy, I really wish I had a couple $100 for something or $1,000 for something. We don't want people that are vulnerable to be taken advantage of with outrageous rates of interest. So what is the maximum interest rate? I honestly don't know off the top of my head. Each state has a certain amount that they determine to be usurious, meaning above that rate is considered illegal. Below that rate is legal. The federal level, I believe, is somewhere around 34%, and most states mirror that. So if you're charging more than that, what happens? I'm not doing anything immoral. I loaned my friend $1,000. He's going to be paying me back $2,000 in 6 months. It's a 200% interest rate. That's illegal. So what happens? Do I get none of my money back? Depends on the jurisdiction, and I don't test you on this specifically because it would depend on the jurisdiction. Some jurisdictions will say, well, Jim, you've charged a usurious rate. Your rate is going to drop down to the maximum rate, which I think is somewhere around 34%. Well, that's great. I still make some money on it. I'm still not going to go to jail for it. I'm not committing a criminal act because I'm not really a loan shark. But I would not be able to collect the full amount that I was charging because it was just usurious. Other jurisdictions say it shouldn't go down to the maximum rate. It should go to a rate called the legal rate. This is where we know the parties wanted to incur an interest rate, but they either were flawed in the way in which they articulated by creating a usurious rate, or they simply left the rate absent in the contractual agreement. In Massachusetts, for example, the legal rate is 12%. So if I say I'll loan you money at an interest rate, but we never articulate what it is, it'll default to what we call the legal rate. Massachusetts, 12%. Other states are different. And then we can put any rate in between 0 all the way up to the maximum rate. So we can charge 5%, 7%, 8%, 9% per annum, whatever it is, as long as it doesn't go beyond the maximum. Some jurisdictions, again, will drop it down to the maximum rate if you go over the usurious rate. Some will drop it down to the legal rate. Some will say because you're committing an illegal act, you only get your principal back. The other party shouldn't get a windfall out of it, but you shouldn't make any interest because you're doing something illegal. Some jurisdictions, if it's severe enough, will treat it as loan shark, and you might actually lose your right to even collect the principal. It depends on the jurisdiction and the egregiousness of the nature of the interest you're trying to charge. It's an important concept because many people buy goods on consumer credit. You know, I can't afford it now, but I'd really like to get that washing machine today. Oh, look, Home Depot, says we can buy it today, no cash down, and we can pay over 12 months, and we're going to pay more. We're going to pay some interest. What is the interest? Obviously, these larger corporations are going to have legal counsel to know that, well, one, we want to make an attractive rate so consumers are interested in it, but others are going to say, let's make sure we don't violate the law and maybe lose some rights and maybe lose some of the interest we wouldn't have gotten otherwise. I know my credit cards, I have a very good credit rating, but my credit card rates are really exorbitant. I think I'm paying 21% on one of my cards. I'm just not disciplined enough to go out and hunt for better interest rates. But those are things you should know as both a consumer, but also as maybe a lender of money. You might be involved in business transactions and somebody wants to buy your truck for their business and you want to sell it, you want to make the money. They may not have the cash up front. You may say, well, why don't we sell it for that price, but you'll sign an IOU and you'll pay me over monthly installments with some interest involved. Make sure you don't go over the usurious rate. You might have to do a little research. I just want you to know the principle of illegality with usurious rates. Important concept. Contracts of an unlicensed operator. This is really interesting. So say I want to sell my house. I don't know about hiring a realtor, but I got a bunch of friends. We're hanging out. We're drinking some coffees. And one of my friends says, hey, I'm really into putting stuff on the internet. I'm into this, I don't know, Pinterest stuff I don't do, Facebook and Craigslist, and I'm a marketing whiz. Let me try to sell your house, and I'll charge you 3% of the gross sale. And I said, yeah, okay. I don't owe you anything because it's a contingency contract, meaning I don't owe anything unless you perform on your end. It's kind of a unilateral contract, but I give you consent to go and do it. You go out and you find me a prospective buyer that's willing and able to pay the amount of money I wanted. I'm all happy, right? They come up, they give me the money. Do I owe my friend 3% of the gross sale? That's what I said I'd pay. And let's assume we put it in writing and we had a notary do it. And everyone's moral and appropriate. Would I have to pay it if they were not a licensed realtor in the state of Massachusetts? The law says no. You do not have to pay for the services of an unlicensed operator where a license is required. In Massachusetts, a license is required to do real estate sales. It's kind of surprising because the other person did everything appropriate and got exactly what I wanted out of it. Same as a lawyer. Say I'm a lawyer right now, I'm licensed, but for whatever reason I let my license expire, I don't pay my dues or something like that. And then you hire me to do some work for you. You find out in the end when payment comes due, I do all the services, you find out I don't have a legal license. I'm going to sue you now because you didn't pay me the $2,500 I was going to charge you for your divorce. Could I actually enforce that contract? The first thing a judge is going to ask me, where is your law license? Or at least proof of your law license at the time you perform the contract. And if I didn't have one, the law will not make me pay that amount of money. And I can't get what we call quantum merit. We talked about unjust enrichment. Why? Because otherwise the law would be circumvented, because we want people to become licensed. Most licenses are for what? To show knowledge, integrity, skill, competence. So that's why we will not enforce even unjust enrichment monies to be paid for the non-licensed person in those areas that require licenses. Sometimes it's surprising. I have a friend of mine who's a barber, and I was teasing him that I saw his barber license up on the wall. And these people have to charge a fee to do hair. To get a haircut is actually a license requirement, and in theory, I don't know who would do a haircut and give me a bill and I pay it later, but you can see how it's really an interesting phenomenon where you don't have to pay people that are unlicensed where a license is required. Some people have licenses in certain areas, but you don't necessarily have to be licensed to perform that service. Now, here's the big exception. A lot of you might get it wrong on the test. Hopefully, some of you are watching this video and reading the book with some diligence. Sometimes the license isn't reflective of a person's knowledge or ethical skills in an area or experience. The license is designed solely to raise revenue for the government. In those rare circumstances, the contract is still fully enforceable and you'd have to pay the unlicensed person, but they would be subject to government punishment for operating in an area where they were required to have a license. Where this is might be, now ride sharing has changed a lot, but when I was a kid, you had to have something called a medallion to be a taxi driver. I don't know how it worked, but it was fairly competitive. They were worth a significant amount of money in the cities. But say I started basically driving people around for a fee. I'm not a licensed cabbie. I'm not a licensed rideshare person, and say that community does require a license. If the license did design, maybe you had to take further driver education classes or have certain other skills, but if there was nothing to do with better knowledge or skills or safety, then the fee would probably be fully enforceable against you if I was doing a ride service for you, but the government might punish me for not having been licensed. So what's the rule? Generally speaking, if a license is required to conduct business or services in a certain area, and you are not licensed, you cannot charge a fee and you cannot enforce that contract in law. What's the major exception? When the type of license is solely designed to raise money for the government and it has no reflection upon the integrity, the skill, or the ethical standards that that person possesses. Pretty narrow exception. It's not going to come up too much. The next one, prohibitive articles. That's very easy. I'm going to buy, I don't know what would be prohibited. I'm going to buy some green sea turtles for you for my aquarium, and let's assume green sea turtles are an endangered species and are not subject to being sold at a pet store. That's a prohibited article. The contract is void. It can't be enforced. It's common sense. Certainly the obvious ones are drugs. I want to buy a certain amount of heroin from you. You don't deliver. I'm not going to sue you on that contract because it's a prohibited article. Some things that are prohibited articles aren't always necessarily immoral. I think about fish a lot for some reason. I had a koi pond on a property I just bought here, and my wife wanted to let them go in the woods. They don't live on land. So out of some weird sense of humanity towards my fish, I had to find a buyer that would take them. I gave them away. But my point was, I was thinking, geez, my father was an eccentric character. I was thinking, boy, I could turn a koi pond. I could put some native fish in there. I think it's illegal to sell certain native fish. I'm not sure, but I'm just saying, what if it was? It's illegal to sell sunfish and yellow perch and pumpkin seed and white trout and yellow trout and all these, not white trout, white perch and rainbow trout, those are illegal unless you're a fishery, licensed fishery or something like that. And I try to stock my pond by going out and fishing for those things in the streams, or I try to buy them from somebody. That contract might be for a prohibited article. Nothing about immorality there. We just didn't know the law existed. Fireworks, I always thought about as a kid. I think the statute of limitations run, so I'm safe to say my brother and I used to sell fireworks illegally in Springfield when we were kids. We were kids. I think we knew it was illegal, but we still didn't. We didn't think it was the most heinous infraction. But those are illegal contracts in Massachusetts, and they wouldn't be enforceable. Common sense for the most part. And this is the one that's not so much common sense. It's called contracts in unreasonable restraint of trade. There are several rules and regulations, and you don't always know them, that prohibit us from engaging in certain business practices because the laws determine that it hurts the consumer or it hurts the free market viability. And some of those surprise people. I'm just flipping through the book to see what examples jump out right away. Yeah, the first one is contracts not to compete. Careful on this one. This is a very important one for some of you because some of you may sign these agreements and you want to know if they're enforceable, but some of you may want to have them for your employees. So let's say I'm a lawyer in Worcester County and when I hire a paralegal, I expect them to come in a little bit green and untrained. And I know when they work for me for a period of time, they're going to become really, really knowledgeable and they're going to develop an understanding of my system. Boy, they work for me for a period of time. What's to prevent them after a year or two just, packing up ship and going to a competitor and working for them and kind of not stealing, but using the skills and the knowledge that I've given them during that period of time. I invested a lot of time and effort into that paralegal. I really wish they wouldn't be able to go to work for a competitor in the same community. Can I have them sign what's called a non-compete clause? For a long time, those were considered completely illegal because it restrained the freedom of that paralegal to go work for another employer. We should be able to go for work wherever we want. But the laws also recognize the argument that I had on my side that I should be able to restrain on some level that by part of the package. So in order for you to work for me, I'm going to offer you X number of dollars, but you're going to promise that you won't work for a competitor in, say, just Worcester County for the 2 years after leaving employment with me. Well, there it would probably be upheld as a valid contract. It's not an unreasonable restraint of trade. It's a reasonable restraint of trade because I invested in you some time and effort. So what if I said you're not going to work as a paralegal anywhere in Massachusetts for the rest of your life after leaving employment with me? That would be unreasonable. It goes too long and too vast in geographical area. So these non-compete clauses are legal if they're reasonable in time and in geography. This also comes up a lot in business. Some of you want to get into business. I still toy with different concepts of entering businesses that I know nothing about. Usually I get a dose of reality when I get close to the investment time and I back away. But say, for example, you want to open up a little small restaurant. There's an elderly couple in town that's been running a really successful small-time restaurant. You love the atmosphere there. You love the place. You come to actually meet the owners. Then one day they say, we're thinking about selling. And you say, well, I'm thinking about buying. And you start a negotiation. You come up with a price to buy their property and their menu, and you learn about their system, and everything's going great. What's going to prevent them right after you buy it from opening across the street, Mamma Mia's original Italian gourmet restaurant, formerly at 123 Main Street, is now at 321 Main Street across the street? Many of the customers are going to go to the original owner, and you're going to be like, well, but I bought your business from you. How can you do this? This is going to undermine the very purpose why I bought your business, because I want to get the goodwill in the establishment and in your recipes and all those things, and it seems fundamentally unfair. They could do it unless you signed what? A non-compete clause. You buy their business, and you say, as a result of me buying your business, you also agree not to open up another Italian restaurant, or any restaurant maybe, within, say, 5 miles for the next 2 years. You can do things like that, and it's a very valuable tool. Hairdressers get involved in it. I don't know if it's this class, but I know I've had many cosmetologists in my classes in the past, and they want to get a business administrative. Someday your goal is to open up your own salon, maybe buy somebody else's salon from them. You don't want that person to turn around and open up the same exact business right next door after you bought it from them. You're hoping to keep the same client base coming to that address. So it's a nice tool to have, but it's got to be what? Reasonable in terms of not only time, but also reasonable in terms of geographical distance, or they're held as an unreasonable restraint of trade. The next one, contracts to limit competition. That's basically trying to become monopolistic. The only example I can come up there, say I own a convenience store and Pepsi comes in and says, hey, we're going to give you a great deal on the wholesale price of Pepsi. You're going to sell at your store. You're going to make a nice profit. It's going to be great. But as part of that contract, you can't sell any Coke products here. If it's framed in a certain way, it doesn't really sound that bad. It sounds like a pretty decent, yeah, okay, you give me a great price, I won't sell Coke. But can you see how that's it's putting a chilling effect on competition, and it's also putting a chilling effect on the availability of the consumer to have competitive goods. There's ways around it on some level, but it's a little bit more subtle. What they do is Pepsi will say, I'm using Pepsi as an example, I hope no one gets mad at me, but Pepsi will say, oh, as part of the agreement for us to, we're going to give you a cooler, but the only requirement is in the Pepsi cooler, you can only keep Pepsi products. That's a little bit more reasonable, but you can see how they're still trying to deter the competition from coming in and selling the product there. Basically, you can't do those kinds of non-compete contracts to limit competition. The next one in the book is contracts to fix the resale value. This surprises a lot of people. Say I sell Timex watches. I'm the Timex company, and I got my little Timex swimming watch I use. If I was Timex and I was going to sell these at Walmart and Target, I call it Target, Kohl's, Kmart's gone now and Sears are gone, but all these different retail establishments, I'm selling the product through a retailer. And I say, I really think you should sell these watches for $39.99. I can't fix that price. Manufacturers cannot fix the price at which their goods are resold in the market. They can do something called, and some of you might have seen this on automobiles and other products. You ever seen this, the three number or the four letters there, the acronym MSRP? That stands for Manufacturer Suggested Retail Price. And the reason that's there is they can't actually fix. That's called price fixing. They can't fix the price that the retailer has to sell it for. Many retailers do sell it for the exact amount that the manufacturer suggests, which they're free to do. But are they required to do it? No, they're not. Some people say, well, that's not true, Jim, because I went to buy some chips and the Doritos bag sold by, I think it's Frito-Lay, whatever the company is, they already have a pre-printed price on it. So they clearly are fixing the price. But what's the supermarket free to do? They're free to put a sticker right over that suggested price and change it and say 2 for that price or on sale for $1.99. They make it sound like it's a sale. They're free to do that as well, too. They just can't do price fixing. The only time they can do price fixing is they're selling directly to the consumer. So I have an Apple laptop here. Actually, I'm using a different one. But if I had my Apple laptop here, I bought my Apple laptop where? I went to the Apple store at the mall, and I bought directly from the manufacturer's outlet store. Now they can set the price because they are selling directly to the public. That's the difference. So that surprises people, that concept of reselling goods, that the manufacturer can't set the price. They can't, because it's deemed artificial, and it should be based upon the competitive juices of society, what the consumer is willing to pay. Obviously, the reseller is not going to pay less than what they paid for it. And that might actually be which brings us to the next one, unfair competitive practices. What if I was a store that really wanted to drive a competitor out of business and therefore get a lot more customer base? Maybe I have a lot of capital. I'm very healthy in my finances right now. Maybe I'll go so low. I'll buy this computer from, this one's a Lenovo. I don't know who makes it. Maybe it's Lenovo. I have a Lenovo computer and I bought it from, maybe I'm the manufacturer called Lenovo, and I'm charging Staples and Walmart and all these other companies $800 for the computer. We're giving an MSRP for $950, but you retailers, you can sell it for whatever you want. Well, what if I'm Staples and I say, you know what, I really want to drive Walmart out of the computer business. I'm going to sell it for $750. Well, why would I sell the product for less than what it costs me to get from the manufacturer? Because I'm trying to do an unfair competitive practice, drawing my competitors out. I'll get hurt for a little while, but I'll crush competition. And once they're gone, what will I charge for the computer? A lot more, because I'll be the only show in town. That is considered an unfair practice. In fact, Walmart has been sued on that for a couple of times. Walmart allegedly did it. They won the suit, though. They were charging, I think it was over Matchbox or Hot Wheel cars. They were charged less than what it actually cost them to buy it. And they said, no, it wasn't because I was trying to drive out of business KB Toys or Toys R Us. What we're trying to do is we kept our Hot Wheels cars way in the other side of the store to require the consumer to go through our housewares and our food and our clothing to get to the Hot Wheels, to get a huge discount on the Hot Wheels. They probably end up leaving with some Clorox wipes and some peanut butter and a new 6-pack of Fruit of the Loom underwear. And they said it was a legitimate marketing tool. And I think they were successful in that. It's pretty interesting, this concept of unfair practices. And they talk about in the book, I don't know if you give any, discriminating in prices between buyers. So I'm selling Timex watches I'm selling them to Staples for $22. They can set the resale price, but I'm selling them to Walmart for $21. You can't do that unless there's a difference in the volume that they're buying, because that's a legitimate reason. You can't favor one retailer over another. You got to be equitable in the way you do things. Administrative agency orders, that's a big deal. We have the FCC, the Federal Trade Commission, FTC. Acronyms always screw me up, but they make sure that business practices aren't really trying to hurt the consumer, and competition stays healthy and free. And then the next one is contracts that are contrary to public policy. There might not be a specific law written down, but we know it's damaging to the public welfare in some way. And they give examples like the freedom of marriage. Careful, there is some, like, say I paid my daughter, she just got married 2 weeks ago, as a matter of fact, but say I paid my daughter $25,000 in a contract never to marry. That contract is against public policy, because freedom to marry is a fundamental right, and you can't give up that right permanently. But what if I said to my daughter, I'll give you $50,000 not to marry till you're 25? That would probably be upheld as a reasonable restraint on the sanctity of marriage, because, well, one is it's not a lifetime ban, and the other is it probably serves a reasonable societal function. The older people that marry tend to, maybe not anymore, but they might have more of a successful marriage. So usually, generally speaking, and also the opposite's also true. I pay someone to divorce their spouse. That contract is void, even if it's a good thing. Like, I have a friend and she's married to a real jerk, and I think the only reason she's staying in the marriage is because of the economic power that they get from being a couple. And I say, you know what, I'm basically going to finance a period of your life. Divorce this jerk, I'll pay you the money. That is a illegal contract to incite divorce action between a couple. A contract obstructing the administration of justice. I always used to ask this for my law students that were majoring in legal studies. Is it always illegal to pay a witness? Well, when you hear always true, always pick false. Not always, because if I'm hiring an expert, it has nothing to do with the case, but I need their scientific knowledge to go in and say that the measure of a skid mark, based upon the weight of that car and the type of traction and the speed they were going, must have been equal to 55 miles an hour at the time of impact. Right? You need a scientist. Is a scientist, they just come to testify for free? No, they can be paid. They're called expert fees, and that can be inquired about from the opposite attorney. Is it true that Attorney Corman paid you $2,500 to testify? Yes, and you told me the most important thing was to testify truthfully. So, yeah, it's not always illegal to pay a witness. But what if it was an eyewitness to an event? And I say, I want you to come in and testify as to what you saw. And what you saw was X, Y, Z, and I'm going to give you $2,500 to come in and say those things at court. That's a contract obstructing justice, just like trying to pay jurors or the district attorney to, punt on a case. Those are obviously illegal. Also, promising in a political campaign that if you vote for me, I'll help you or your spouse or your kid to get a job. Although we know those things happen all the time, they're clearly what? They're not enforceable because they're contracting, obstructing justice. And that relates to publish contracts injuring public service. I already alluded to that. I always think of them as the same thing because they're really of the same ilk. You can't pay people to basically run for office to help family members, or I'll get you those contracts. And that relates to one of the questions. I know some of you answered it already. I usually don't take any points out if you get it wrong. There's one right here in, I think, in Lunenburg, Mass, where they didn't go through what's known as the open bidding process, and they awarded a contract to Balthasar Construction, a huge construction company here in New England, maybe even beyond. They were doing a great job, and it was a very good price, and they were going to be fantastic. The problem was that somebody else come along and says, how did Balthasar get that contract? I'm a competitor. I wanted a chance to bid on that contract. And they tried to undo the contract, saying it was illegal, even though Balthasar already had done some work, and they tried to argue they should get at least quantum arrow it. Quantum arrow, it's unjust enrichment. They shouldn't get anything because it was an illegal contract. Not necessarily immoral. No one's trying to commit a crime. They just short-circuited the legal process by which a contract was awarded in the town of Lunenburg back in the day. That contract's illegal. It's unenforceable, and you can't, because it's illegal, you can't try to argue unjust enrichment, because unjust enrichment, remember what the elements requires. Justice requires payment of some reasonable fees. Justice never requires payment of something when it's based upon illegality. And that's pretty much it for this chapter. It went a lot longer than I thought it would. It's more of a straightforward chapter anyways. But that covers, I think, this module information. Next chapter is Chapter 11. It will give you some of your relief because Chapter 11 is Really, sometimes contracts do have to be in writing. Most of you probably entered the class that anytime you enter a contract, it has to be in writing. Not so. Only has to be in writing in certain circumstances, and we'll go over that in Chapter 11. I hope to have that up. I don't know. Maybe I'll try to get it over the weekend, try to get it up so some of you get ahead of the game if you watch these things. Otherwise, have a good weekend if I don't get on before then. Take care.